So hello everyone, I hope you all are doing fine. So a very warm welcome to today's YouTube live session. आज के सेशन में हम डिस्कस करेंगे सुप्रीम कोर्ट की कुछ इंपॉर्टेंट जजमेंट्स जो पिछले पास्ट 2 वीक्स में आई हैं. So without wasting any time, let us start with them one by one. So the first judgment that we have is Hero Motocorp Limited versus Union of India. Now what was the issue in this judgment? The issue raised was whether, despite a subsequent statute specifically providing for rescinding the benefits granted under an earlier statute, the union government can be compelled to stand by the representation made by it through the earlier notification. So what was the main issue? The issue was whether doctrine of promissory estoppel could operate against a statute. Now let me explain it to you in very simple words. Suppose in the year 2000, a notification was issued by the central government which gave certain benefits to a category of people. Alright, so in year 2000, a statute or an act came into being by which certain benefits were given to a class of people. Now, a notification B was published by the union government in the year 2005, by way of which these benefits were taken away from those people. Now what was the issue in this? There is a similar issue in this judgment also. The people are alleging that if the government has earlier promised someone, then later on it cannot resile away from it. That is, it cannot deny such benefits to people, and the government is bound by the principle of promissory estoppel. So another important concept that I would like to explain in little detail is the concept of promissory estoppel. A promissory estoppel क्या होता है? When you or somebody else, by your act or your conduct or any of your statement, makes someone believe that the statement or the act you are doing is true in its nature, and acting on your statement if the other person does something. ठीक है, तो फिर later on you cannot revert back or you cannot deny making those statements. You are bound by the promise or by the statements that you have made. So what happened in this case? The issue was whether doctrine of promissory estoppel could operate against a statute. So what did the court say? There can be no promissory estoppel against the legislature in the exercise of its legislative functions. इसका मतलब क्या हुआ? गवर्नमेंट के पास अथॉरिटी है या पावर है कि वो स्टैट्यूट्स को या लॉज को चेंज कर सकते हैं, एंड दे आर नॉट बाउंड बाय द डॉक्ट्रिन ऑफ प्रॉमिसरी एस्टॉपल. अल्टीमेटली हो सकता है इस चेंज से किसी को कुछ डिसएडवांटेज भी हो, बट the union government or for that matter even the state governments, they are not bound by the doctrine of promissory estoppel. Now what else was held in this case? Now what is the exception to this rule? The general rule is the promissory estoppel does not apply to the acts of the legislature. Now what is the exception? When can this doctrine be made applicable to the acts of legislature? The only exception is with regard to applicability of the doctrine of estoppel is where it is necessary to prevent fraud or manifest injustice. Where such a change in the statute is done with an intention of committing a fraud, or where such a change has led to injustice to someone, in that case the doctrine of promissory estoppel can be applied. So these are the just two exceptions where the doctrine of promissory estoppel can be made applicable to legislative actions. Now what further has been stated? The Constitution bench, in this particular judgment, the Supreme Court has relied on a very landmark constitutional bench judgment. What does it say? In the case of M. Ramanatha Pillai, has approved the view in American jurisprudence that doctrine of estoppel will not be applied against the state in its governmental, public or sovereign capacity. So the general rule has been laid down by the Constitution bench in severe judgment, but the landmark judgment regarding the same was M. Ramanatha. where the Supreme Court clearly stated that this doctrine of promissory estoppel will not apply to sovereign actions of the state. Okay, so that is all the crux of this particular judgment. Now with this, let us proceed to the next judgment. So next judgment we have is Mariano Anto Bruno versus Inspector of Police. Now what happened in this case? It held that to convict a person under section 306 of IPC. Now what does 306 of IPC talks about? It talks about abetment to suicide. Okay. Now in relation to this, there has to be clear mens rea to commit the offence. It also requires an active act or direct act which leads to deceased to commit suicide, finding no other option, and the act must be such reflecting intention of the accused to push deceased into such a position that he commits suicide. Now this particular case is in relation to section 306 of IPC, which talks about abetment of suicide. तो इस केस में सुप्रीम कोर्ट ने कहा that the prosecution has to prove it directly by the direct evidence or the circumstantial evidence that the deceased person has committed a suicide because he was affected by the acts of the accused. Okay? Now mens rea has to be proved. And who will prove it? It will be the prosecution who will be proving the mens rea. Now let us discuss a little about the concept of mens rea. As we know, under the Indian Penal Code or in general, to constitute an offence or to constitute a crime, there are two essential elements which are required. One is your mens rea, other is actus rea. So mens rea means there has to be a guilty mind or guilty intention when you are committing the offence. Actus rea is a wrongful act. Alright, so both these things should coexist to constitute an offence. Likewise, for the offence of abetment to suicide, the Supreme Court has said that the element of mens rea has to be proved. What does it mean? That is, the prosecution has to prove that the deceased has committed suicide because the accused person has pushed him to such an extent that he had no option left but to commit suicide. Now, what further has been held in this judgment? In cases of alleged abetment of suicide, there must be proof of direct or indirect acts of incitement of the commission of suicide. Now, what needs to be proved? The prosecution has to prove either by giving some direct evidence or by giving some circumstantial evidence that it is only because of the acts of the accused or the behavior that he had towards the deceased person which led to the commission of suicide by the deceased. So what will be the standard of proof again for the prosecution? The prosecution has to prove the guilt of the accused beyond reasonable doubt. ठीक है, सो इसके बाद और क्या चीजें डिस्कस की गई इस जजमेंट में, लेट अस डिस्कस दैट टू. So Supreme Court also stated that merely on the allegation of harassment without there being any positive action or proximate to the time of occurrence on the part of the accused which led or compelled the person to commit suicide, conviction in terms of section 306 IPC is not sustainable. So what did the court finally say? That there has to be a proximate relationship between what? The act of accused and commission of suicide by deceased. So this is what was laid down by the Supreme Court, that there has to be a proximate, if not direct link, but at least a proximate link should exist between the act of the accused and the death or the commission of suicide by the deceased person. Now this is all about this particular judgment related to abetment of suicide. Now let us proceed further to the next judgment. इसके बाद जो हमारी नेक्स्ट जजमेंट है, इट टॉक्स अबाउट juvenile as accused. So what happened in this judgment? Basically, there was a 16-year boy. He I guess what happened in this judgment was basically he murdered a 7-year-old boy brutally. He slit his throat and he left him to die. So इस केस में क्या हुआ? The person who has committed the offense, he was just 16 years of age. So 16 years of age के accordingly हम उसको juvenile consider करते हैं. Now what is the juvenile concept of juvenility? We have the Act of Juvenile Justice Act, जिसमें basically हमारा क्या provided है कि if any person who is below the age of 18 years of age, he will be tried as a juvenile. Now when somebody is being tried as a juvenile, उसके पास कुछ advantages होते हैं, ठीक है? That the maximum punishment that can be imposed on that person has been defined under the JJ Act. उसको और भी कई benefits provide किए जाते हैं, like he will not be kept in the regular jails, but that person will be kept in, either if he is a minor, he will be kept in the children home or in the observation home. So likewise इस judgment में it is also related to juvenile as an accused and his rights to get a bail. तो इस judgment में क्या हुआ? A division bench of Supreme Court of India granted interim bail to the juvenile accused for the murder of a 7-year-old boy. So who committed the offense? This juvenile, this person was of 16 years of age, and the person who died, he was 7-year-old boy. Okay. So this comes on the heels of a decision of the Juvenile Justice Board that held that accused is to be tried as an adult. Now usually whenever there is a age gap of the juvenile is between 16 to 18 years, it is the discretion of either the court trying the offense or the Juvenile Justice Board. If the Juvenile Justice Board thinks that कि जो offense का commission का तरीका है, it is so grave and heinous that the juvenile should be tried as an adult, तो उस केस में है Juvenile Justice Board, even if the person was 16 years of age at the commission of offense, he can still be tried as an adult. That means जो JJ Act के अंडर जितने भी advantages हैं वो सब उसको नहीं मिलेंगे. Now an interesting legal point came up during the discussion was whether section 12 of JJ Act could be repressed into service by an adult accused of a crime committed while they were a juvenile in order to get bail. Now section 12 क्या है Juvenile Justice Act का? Section 12 of Juvenile Justice Act says that if any person when he committed the offense was a juvenile and he is in the custody of police or he is kept in the observation home, he will be given a bail by the court. ठीक है? A right has been given to the juvenile. But in this case, what happened? When he committed the offense, the accused was of 16 years of age. And later on, when he is claiming the defense under section 12, he is now 21 years of age. So this dispute arose in the court. Now that person is not a minor, not a juvenile. Can he claim the benefit under section 12? The Supreme Court has referred this matter to the larger bench or has kept it for consideration. And in the meanwhile, the Supreme Court has granted him interim bail because that person, that juvenile, has been in the custody of police for last 5 years. So only and only considering the period of his custody, interim bail has been granted to this juvenile accused. Now, what else has been discussed in this judgment? The court noted that the accused who was arrested as a 16-year-old. So, when he committed the offense and he was arrested, his age was 16 years. He has been lodged in a correctional facility for almost 5 years. So, he has been in prison for last 5 years. So, whether a bail application is maintainable under section 12 or it is not maintainable, it is a question that we will examine or determine whether it has to go to 3-judge bench. So whether this person can claim the benefit of section 12, that will be decided later on, but right now he is claiming a bail और Supreme Court ने उसको interim bail grant की, considering that the accused has been detained for 5 years and have he been able to balance the competing considerations. ठीक है? Because he also has the right to life and liberty, he has a right to bail, right to get a bail, because he has been in prison for last 5 years and his matter has not been heard properly. So in this case, Supreme Court, considering all the circumstances, has granted bail to this juvenile accused. So this is all about this judgment. Now next after this we have another very important judgment, which is State versus Laly aka Manikandan. Now this is recovery of weapon used in the commission of the offence is not a sine qua non to convict the accused. तो सुप्रीम कोर्ट ने इस जजमेंट में क्या कहा, merely because the prosecution or the investigating authorities has recovered the weapon of the offence with which the offence has been committed is not a ground for conviction. There are several other factors which are kept in consideration by the Supreme Court. If there is a direct evidence in the form of eyewitness, even in the absence of recovery of weapon, the accused can be convicted. So what has higher evidentiary value? It is not just the weapon that has been recovered, but the evidence or the testimony of the eyewitness. So always the court gives higher weightage or higher value to the statements given by the eyewitness. Even in the case of some contradictions with respect to timing of lodging the FIR or complaint cannot be a ground to acquit the accused when the prosecution case is based upon the deposition of a eyewitness. So what else the Supreme Court stated here? Just because there has been a delay in filing of the FIR or the complaint by the victim or the person who is injured, it will not be a ground to acquit the accused. Only and only if there is a reliable testimony of an eyewitness. So from all these 3 points, what we can make out, that the testimony of eyewitness is on the highest pedestal as compared to the other circumstantial evidence. और इस जजमेंट में क्या डिस्कस किया गया, that there can be a conviction on the basis of deposition. Deposition is testimony or a statement of sole eyewitness if the said witness is found to be trustworthy and or reliable. So a conviction can be based solely on the testimony of an eyewitness, provided that eyewitness is trustworthy and he is reliable. Okay? So this is all about this particular judgment, which talks about reliability of the testimony of an eyewitness. With this, now let us proceed to the next judgment. So next judgment is Manoj Kumar Tiwari versus Manish Sisodia. So this case, what does it talk about? Defamation in relation to public servants. So what did the Supreme Court say or observe in this case? Supreme Court observed that a minister or a public servant is a person covered by section 199 clause 2 of CRPC that we will be discussing later. He can file a private complaint alleging the defamation and need not follow the special procedure prescribed by 199 clause 2 or 199 clause 4 of CRPC. The special procedure, Supreme Court further held this point also, that the special procedure is an addition and not in derogation to the right of a public servant. He always has an individual right. He never lost his right merely because he has become a public servant and merely because the allegations related to his official discharge of duties. Now, for understanding this, now let us first discuss what is section 199 of CRPC. What does it say? So section 199 of CRPC, it says that it provides a special procedure when the offence of defamation is alleged to have been committed against a person who at the time of such commission is a public servant. Meaning an offence of defamation is committed against a public servant. In such a situation, the court of session may take cognizance of such offence without the case being committed to it upon a complaint in writing made to it by the public prosecutor. मतलब क्या हुआ इसका? Whenever an offence of defamation is committed against a public servant, the court of session will take cognizance of this matter only and only if a complaint in writing is made by the public prosecutor. Now, what did the Supreme Court say here? this provision of 199 CRPC, it is not in derogation of the right of the individual, even though that person is a public servant. But this provision of CRPC does not take away his individual right to institute a FIR or complaint against the person who has done or who has committed the offense of defamation against him. So further 199(4) क्या कहता है? It further provides that such complaint can be made by the public prosecutor only with the previous sanction of the concerned government. Okay. So one more additional condition has been added in cases of public servant defamation matters. First of all, it will be the public prosecutor who will be giving your petition in writing, and also prior permission of the central or state government has to be taken. Now, Supreme Court has stated that both these provisions will not affect his individual right to take an action against someone. Okay? So, these are the provisions are in supporting the individual's rights, and they are not in derogation of the individual rights of the public servant. Okay? So, that is all about this particular judgment. That meaning that the public servant will not have to wait for the public prosecutor to give the petition in writing after taking the permission from central or state government. He can himself go to the police officers or the concerned magistrate and make a complaint regarding the defamation done against him. All right. So, that is all about this particular judgment. Now, after this we have, all right. So, that is all with the important judgments of past 2 weeks. If you really like the video, you can subscribe to our channel and listen to more such informative videos. Thank you. Everyone have a good day.